Hello everyone, and welcome to my presentation on the article History and the Debate over Intellectual Property. Intellectual property is a complex and important topic that affects many areas of business and society, and this presentation will provide a comprehensive overview of its history and current state of debate. To give you all the overview, I will be covering several important topics, starting with the definition of IPR and ending with an overview of IPR in Canada. The structure of this presentation is as follows. Firstly, I will discuss the definition of IPR and what it encompasses. This will provide us with a basic understanding of the legal mechanisms that protect creative and innovative works. Next, I will talk about the institution-based view on IPR. This view recognizes that the legal and regulatory environment can shape the behavior of economic actors, including their incentives to innovate and protect their intellectual property. Moving on, I will examine the history of IPR in China and the United States. We will look at how these countries have transitioned from having weak IPR protection to being champions of IPR and what factors drove this transition. Finally, I will provide an overview of IPR in Canada. We will examine the legal framework for IPR protection in Canada, including patent, trademark, and copyright law. By the end of this presentation, I hope to have provided you with a comprehensive understanding of IPR. So let's begin with the definition of IPR. IPR refers to legal rights associated with the ownership of intellectual property. These legal rights include the right to exclude others from using, reproducing, or selling the protected works without the owner's permission. IPR is primarily composed of three main rights: patents, copyrights, and trademarks. Patents are used to protect inventions, while copyrights protect literacy, artistic, and musical works. Trademarks, on the other hand, are used to protect brand names, logos, and other distinctive marks that identify the origin of a product or service. It is important to note that intellectual property specifically refers to intangible property that is the result of intellectual activity. This includes the content of books, videos, websites, and other creative works. Intellectual property is a vital asset for creators and innovators, and IPR plays a significant role in ensuring that their hard work and innovation are protected. This presentation has a twofold purpose. First, the main purpose is to provide a comprehensive overview of the history of intellectual property and the current debate surrounding it. The aim is to explain the concept of intellectual property, its evolution over time, and the role of patents, trademarks, and copyrights in protecting intellectual property. It will also discuss the challenges associated with enforcing these protections. Second, the purpose is to provide a balanced view of the debate over intellectual property. The authors of this article acknowledge the arguments made by those who believe that strong intellectual property protections are essential for innovation and economic growth, as well as the concerns of those who argue that intellectual property rights can stifle innovation and limit access to essential goods and services. By presenting a balanced view of the debate, the aim is to better understand the complexities and nuances of this issue. Before proceeding in detail, it is essential to understand the concept of an institution-based view on IP rights. There are two types of institutions, formal and informal. The institution-based view significantly helps us in understanding the country's IPR protection and IPR violation. The rules of the game of IPR history suggest that the US refusal to protect foreign IPR in the 19th century and the current Chinese lack of enthusiasm to meet US IPR demands represent rational choices. One of the leading propositions of the institution-based view is that individuals and organizations rationally pursue their interests and make strategic choices within the formal and informal constraints of a given institutional framework. Now, let's delve deeper into the culture and politics behind IPR in China. The country has come a long way from having no IPR protection to becoming one of the world's leaders in filing international patent applications. However, the enforcement of IPR is weak, and the country faces significant challenges in protecting intellectual property, particularly in the areas of trademark and copyright infringement. Understanding the culture and politics behind IPR in China is crucial to understanding the challenges associated with enforcing IPR protection. By acknowledging the formal and informal institutions that influence IPR protection and violation, we can better understand how individuals and organizations make strategic choices regarding IPR in China. In conclusion, the institution-based view on intellectual property rights is a critical framework that helps us understand a country's IPR protection and violation. China's journey in this field began from scratch in 1985. However, since then, the country has made remarkable progress. In fact, China has been handling over 1 million patent applications annually since 2010. This demonstrates China's commitment to promoting innovation and research and development activities within its borders. It is not surprising that China already has the world's largest volume of domestic patent applications. China is also one of the world's leaders in filing international patent applications. This means that China is increasingly looking beyond its borders to protect its innovative ideas and products. Furthermore, China's IPR regulations are fundamentally compatible with the latter of the expectations of the World Trade Organization, that is WTO. So, the WTO is a global organization that governs international trade and commerce, and China's compliance with its regulations is a positive development. However, while China has made significant strides in promoting IPR, the enforcement of IPR remains weak. This is an area where the country needs to focus its efforts to ensure that innovators and creators receive the protection and compensation they deserve. The question that has been on everyone's mind: why does China not pay enough attention to intellectual property rights protection? Why are so many Chinese firms and individuals willingly engaged in piracy, counterfeiting, and other acts of IPR violation? There are various debates and discussions on this topic, and we will explore two popular explanations: culture and politics. The cultural argument suggests that Chinese culture, dating back 2500 years, focuses on the importance of personal ethics and morality, leading to a lack of respect for intellectual property rights. Chinese culture still seems to have trouble valuing intangible assets. However, China is currently envisioning a path of better IP protection. With respect to the political aspect, we can see that during the Beijing Olympics in 2008, the sale of fake Olympic merchandise completely disappeared. Similar success were achieved during the Asian Games in Guangzhou in 2010 and the Summer Youth Olympics in Nanjing in 2014. Clearly, we can see that Chinese can be politically motivated and organizationally capable of eradicating IPR violations. In other words, when there is a will, there is a way. It appears that the reluctance to pay attention to IPR arises from the worry that meeting the US demands for intellectual property rights at this early phase may result in foreign IP rights holders benefiting more, resulting in hampering China's growth. However, China is now taking steps to improve IPR protection, with the volume of domestic patent applications and international patent applications filed continuing to rise. When we talk about IPR violations, China is often the country that comes to mind. However, China is not the only country that has shown disrespect for IPR. In the 1960s, Japan was a global leader in counterfeit goods. They were producing counterfeit products ranging from electronics, automobile parts, to luxury items like handbags and watches. The quality of these fake goods was so high that it was almost impossible to distinguish them from the real ones. The Japanese government did take some steps to address this issue, and eventually the situation improved. In the 1970s and 80s, Taiwan, South Korea, and Hong Kong emerged as leaders in producing counterfeit goods. Just like Japan, the quality of these fake products was high, and it was challenging to differentiate them from genuine goods. These countries also took measures to address the issue of IPR violations, and over time the situation improved. It is important to note that IPR violations are not limited to specific countries or regions. It is a global issue that affects all countries. As technology advances, it has become easier to produce counterfeit goods, making it even more critical to protect IPR. It is essential to create awareness and take measures to address IPR violations to protect the rights of innovators, creators, and artists. During much of the 19th century, American pirates were busy knocking off secret British designs for looms and mills, while producers and publishers extensively pirated foreign publications, art, and drama. Hence, the US government stood ready to help IPR violators. From an institution-based view, we can say that the US refusal to protect foreign IPR prior to 1891 was rational. Given the lower levels of literacy and economic development during the 19th century, benefits from the protection of foreign IPR would simply benefit foreign investors, authors, and firms, while domestic consumers had to accept higher costs for books, media products, and innovative goods. In this slide, I would like to discuss the institutional transition of IPR laws in the United States in the late 19th century. In 1891, the United States voluntarily strengthened its IPR laws with the passing of the International Copyright Act, which extended IPR protection to foreign works. But what was the cause for such a major institutional transition in the US IPR regime? Firstly, according to institutional isomorphism, individuals, organizations, and nation states feel pressures to conform to certain norms and expectations, leading to long-term institutional transitions. Additionally, the development of informal institutions, such as clear norms, played a critical role in the institutional transition. Secondly, a significant driving force behind the transformation was likely the pressures from numerous indigenous inventors, authors, and organizations within the United States. As the close of the 19th century approached, the United States had turned from being a net consumer to a net producer of intellectual products. Thirdly, as more American authors, publishers, and producers were eager to market their products overseas, they naturally desired better IPR protection from foreign governments. This led to increasing pressure on the US government to strengthen its IPR laws. Finally, in the late 19th century, American IP was being increasingly pirated elsewhere, especially in Canada. Similar to the Americans, the Canadians offered IPR protection to their domestic investors, authors, and publishers, but did not offer IPR protection to foreigners. Thus, pirating US publications was widespread in Canada, causing an uproar among American publishers and writers, which led the US to start offering IPR protection to foreign authors and inventors. In conclusion, understanding the institutional transition of IPR laws in the United States helps us understand the importance of conforming to certain norms and expectations, as well as the pressures from various stakeholders, including indigenous inventors, authors, and organizations. Now, we will discuss the issue of intellectual property rights violations in the United States, examined through the lens of the institution-based perspective. Through this analysis, we have found two key findings. Firstly, during the United States economic expansion, there were substantial instances of intellectual property rights violation. This indicates that despite being one of the leading nations advocating for IPR protection, the US was not always consistent in its enforcement of these laws. This suggests that the institutions responsible for enforcing IPR protection in the US may have been influenced by external pressures, such as economic factors, which impacted their willingness or ability to enforce IPR laws. Next, while there have been some improvements in IPR protection in the US, they have not been consistently steady or all-encompassing. This suggests that there may be limitations in the institutional framework that suppose IPR protection in the US, which may result in gaps in enforcement or gaps in the types of IPR protections offered. In the next slide, we use the same institution-based lens to shed light on two recent IPR developments in China. Despite the negative coverage in the Western media about IPR violations in China, it is difficult to argue that the Chinese government is not serious about IPR protection. In fact, the total patent applications in China jumped from 476,000 in 2005 to over 1.2 million in 2010. And today, China is the world champion in the number of patent applications. This indicates that the Chinese government is taking a proactive approach to promoting innovation and protecting IPR. Moreover, in 2010, there were 38,945 IPR civil cases in China, while the United States had 6,658 such cases. This shows that China has become the world's most litigious country with respect to IPR. Additionally, the number of IPR litigation cases in China has risen significantly compared to the United States, making China the most litigious country with respect to IPR. The Chinese government has also implemented policies to promote indigenous innovation, which may help encourage the development of local stakeholders. It is encouraging to note that a new cohort of Chinese stakeholders who are invested in improving intellectual property rights protection is emerging. Now we will be analyzing the graph shown in this slide to understand the costs and benefits of IPR protection and enforcement institutions. It is important to note that setting up an institution is a costly affair for an emerging economy. During time 1, the costs of better IPR protection and enforcement outweigh the benefits. However, as time has passed, both Chinese firms and the government have come to recognize that achieving sustained economic growth will require increasing reliance on intellectual property rights. At time 2, enhanced IPR protection and enforcement are more beneficial, thus motivating the emergence of strong IPR institutions, which in turn fuel the more extensive use of these institutions. This is supported by the evidence of a rising number of litigation cases as shown in the previous slide. In concluding this presentation, it is widely acknowledged that history can be a valuable tool in understanding both the past and present, as well as informing future decisions. Instead of relying on strict path dependence or cultural determinism, history helps to explain events and trends while taking into account institutional constraints. In this presentation, we have extended the institution-based view by examining the history of the United States and its transformation from a leading IPR violator to a leading IPR champion. We believe that this history can be used to inform the contemporary US-China debate on IPR. Based on this history, it is predicted that as China's economy becomes increasingly innovation-driven, the country will enhance its IPR protection to the same extent that the United States voluntarily agreed to strengthen IPR protection. We also anticipate that if there is a significant violation of Chinese IPR outside of China, China will become more serious about IPR protection. Therefore, we suggest that China's indigenous innovation policies need to be strengthened rather than discouraged by foreign IP rights holders, governments, and stakeholders. Now, let's talk about the overview of IPR in Canadian context. In Canada, the origin of intellectual property rights can be traced back to the early 19th century, when the first Canadian patent law was passed in 1824. This law established a system for granting exclusive rights to inventors for their new and useful inventions, and provided a legal framework for protecting and enforcing those rights. In the following years, additional laws were passed to protect other forms of IPR, such as trademarks and copyright. The first Canadian trademark law was passed in 1868, which allowed for the registration of distinctive marks used to identify products or services. The first Canadian copyright law was passed in 1921, which provided protection for original literary, dramatic, musical, and artistic works. Canada is a member of several international treaties and agreements that govern IPR, including the World Property Organization and the Agreement on Trade-Related Aspects of Intellectual Property Rights, which is TRIPS. These agreements establish minimum standards for IPR protection and enforcement in member countries. The Canadian Intellectual Property Office, which is called a CIPO, is responsible for administering legal mechanisms and granting rights to inventors, creators, and businesses. Canada has a well-developed legal framework for the protection of intellectual property rights. This framework includes laws and regulations that protect various types of IPR, including patents, trademarks, copyrights, and trade secrets. Through this slide, I would like to share with you some information about intellectual property rights in Canada. Canada has become a significant hub for the protection and application of intellectual property rights, with almost 150,000 applications being received and sent out of Canada annually. The IP Canada report is an annual report that provides insights and trends on the usage of IP in Canada and by Canadians worldwide. The report is based on data collected by the Canadian Intellectual Property Office and the World Intellectual Property Organization. One of the highlights of the report is a Sankey diagram that illustrates the flow of IP applications into and out of Canada by origin and destination. In the center of the diagram is the Canadian flag, with the flow of IP applications to Canada on the left side and the flow of IP applications from Canada on the right side. Each side of the diagram displays flow bars for the top 9 countries that file applications as well as a flow bar for all other countries combined. The width of the flow bars corresponds to the number of IP applications to or from each country. In conclusion, Canada is a major destination and source of IP rights with a robust legal framework for the protection of IPR. Thank you so much for listening to the presentation.